Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to head all the way over to the other side of the country. We're going to go to New Jersey. Why? Well, because we're going to talk about New Jersey Assembly Bill 4769, better known as their Bruen Response Bill. Now, we're not going to get too deep into it, but essentially what happened is after the United States Supreme Court smacked down states like New York and New Jersey and many of the other may carry states, what we've seen these states do is run back to their state legislatures, whining like little you-know-whats, and then pass even more restrictive gun laws. And what they've done is, since they now have to issue concealed carry licenses, they're making their states may carry states. So it used to be a may issue license, now it is a may carry. And they're basically turning their entire state into gun-free zones, or what they're calling sensitive places. No state has expanded that worse than the state of New Jersey. And there has been multiple lawsuits. This involves 2 lawsuits. There was some injunctions, some stays of the injunctions. Finally, the cases got consolidated, and now it is set for oral argument today. And this case is huge for a lot of reasons, especially if you're in a state that happens to be a little blue. I'll explain why and connect the dots. So today, let's spend a few very important minutes and talk about the huge case before the Third Circuit today. Okay, the case we're talking about is the matter of Koons v. Platkin. Now, there was a companion case. It was called Siegel v. Platkin, and it was consolidated with this case. The title of the case is Koons v. Platkin, but there are multiple plaintiffs. It is brought to us by our good friends at the Firearms Policy Coalition. I've had a chance to go through a lot of the various pleadings associated with this thing. This case has been thoroughly litigated, and as usual, if you want to show FPC some love, we'll put a link for that down below in the description box so you can do so. Now, in a nutshell, this is a challenge to all the new sensitive places that the state of New Jersey decided to come up with where guns are now prohibited. And essentially, they have created a situation where you cannot actually exercise your Second Amendment rights anywhere inside the state of New Jersey. Now, 2 things I want you to be aware of. There are a lot of sensitive places that are being argued here. I'm just going to give you a few of the highlights from it so you can understand some of the places that we're talking about, because this is a gun control or civilian disarmament measure coming to your state soon. The areas that New Jersey has banned firearms at include state, county, and city buildings, polling places, within 100 feet of a public gathering, whatever the hell that means, parks, beaches, libraries, museums, places where alcohol is served, entertainment facilities, healthcare facilities, any type of public transportation, and then private property. And that private property one, which is also taking place in California under Assembly Bill 2, is absolutely the most offensive of any of them, because you basically have the government coming in and telling private property owners, we're going to tell you what kinds of restrictions are going to be placed on your property, and you can undo them, but you can only undo them with express permission to each individual. Okay, so these are all of the sensitive places. Now, here's the other reason why this is huge, okay? Because there has been an amicus brief that has been filed by multiple attorney generals. Actually, I know the correct term is attorneys general. That's how you do it plurally, but a whole bunch of them have filed an amicus brief saying, hey, all of New Jersey, these sensitive places, is totally okay and should pass constitutional muster. Now, I'm going to give you a list of the states, because if you live in one of these states, you might realize that, hey, we don't have all of these sensitive places in our legislation yet. Okay, so the states that joined in this amicus brief supporting New Jersey's sensitive place laws included Illinois, California, Colorado, Connecticut, Delaware, Hawaii, Maryland, Massachusetts, Michigan, Minnesota, New York, Oregon, Pennsylvania, Rhode Island, Vermont, and Washington. Okay. So if you reside in some of those states, such as Washington State, hey, listen, we do have some areas that are gun-free zones. Do we have as many restricted areas as the state of New Jersey? Not yet. But I can assure you, if you are in one of those states where your attorney general threw down on this issue here, what's coming to a legislative session real soon is a whole new list of sensitive places, because your state legislature and your state attorney general and your governor is going to want to be able to say, oh, well, the constitutionality of this has already been predetermined by Koons v. Platkin. So This case, which is being argued before the Third Circuit today, is over what sorts of injunctions should be in place. This is not an ultimate argument on the merits, but why is it so important? Well, for the reasons that we've already stated why it's so important, let us not forget what happens when we're arguing for a temporary injunction, because not only do plaintiffs need to show that there is irreparable harm, and certainly a deprivation of what is supposed to be an inalienable right is in fact irreparable harm, but this is the other one, and this is the really important. Plaintiffs must also demonstrate that they are likely to prevail on the merits of the overall argument. Therefore, if the plaintiffs in Koons v. Platkin were to prevail on the temporary injunction, or at least injunction on some of these sensitive places, that will be an excellent sign. We're going to go ahead and put links for everything down below. You can go to the Firearms Policy Coalition's webpage. I think they have a live stream, and they will probably have a replay of oral arguments. The case again is Koons v. Platkin. It is being argued today in the Third Circuit. We'll link it all up again so you can geek out on it. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box. In the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.